Well, back when they asked us to do the first show, back 11 years ago, we said that we would do the show as long as you don't edit in our faith. And they came back and said, well, it's your show, you can share it. And so they've given us the ability to really use the show to include a lot of Bible principles that we live by. And really, that's the foundation for our lives. And that's what we want to encourage people is that Bible principles work. And as each family turns their heart towards God, that they can set their family on a firm foundation.
Hi, besties. All right, you friends. Josh Duggar's rambling 60-page document basically going after the government, Joe Biden, the former President Joseph Biden, declaring that multiple federal agents committed perjury, accusing the government of misusing evidence, and going after Bobby Holt, and all of these different blame games and not being allowed to call witnesses. This document that he filed as a motion to vacate, well, the U.S. attorneys have fired back, and well, they're arguing right now with the court about whether or not his motion was filed in a timely fashion, but they've requested that they strike the document, which the court didn't strike. They're basically giving him a week extension. But I want to just share with you that he has clearly ticked off Dustin Roberts, who is the U.S. attorney that was one of the lead prosecutors in this case. He's the assistant United States attorney. He is in the Western District of Arkansas. He, along with two other U.S. attorneys, were the leads on this case. And Dustin specifically, his background is in prosecuting cases like this and dealing with cases that have a lot of forensic and digital needs. So computer fraud and CSAM type cases. He is an excellent U.S. attorney. He did a wonderful job on this case. His entire team did an amazing job from start to finish. The way that they handled this with care and concern for the victims of this case and for the victims of his past, Josh's past, for his sisters. And they filed their response. They're seeking a request from the court to extend their response time. And the judge granted that they have another week to file a response, which doesn't necessarily address the issue at hand, which is this motion to strike. And what they're saying is that Josh erroneously sent a copy of this motion to vacate to the attorney's office in Arkansas. And what's weird is that the envelope arrived at the attorney's office without the stamps being canceled through. So it's unclear how this envelope ended up at the attorney's office, because when you send something through the mail, it gets scanned and then the stamps all get canceled out. And for some reason, this ended up without that. The postmark never went through. And they're kind of questioning that. And they're saying that it was sent to the wrong office. And then the clerk in this court ended up filing it as though it was properly mailed. So their argument is that they want them to strike the document that had been sent on the date of his deadline, which was, I think, June 24th. And they want it to be switched to this duplicate one that came in a month later. It's kind of confusing. I'll show you in a second. So they want them to strike the 179, which is a motion to vacate. And then they want them to identify document 182 that was filed as a duplicate copy as the correct one. Their procedural background reminds the court that he was charged in a 2-count indictment by a grand jury. And one was he was charged with receipt of CSAM in violation of 18 USC Code 2252A, A2, and count 2 charged with possession. And then on December 9th, after an 8-day jury trial, he was convicted on both counts. And then on May 25th, he appeared before the Honorable Timothy Brooks for sentencing. And then at sentencing, the court dismissed his possession conviction, which was count 2 of the indictment, on the basis that count 2 was a lesser included offense of the receipt conviction under count 1. The court proceeded to sentence Duggar to, among other things, 151 years or months in prison, to be followed by 20 years of supervised release. And with the 20 years of supervised release, there's a lot of stipulations. And within that supervised release, if he screws up at any time, he can have his release effectively revoked and he can go back to prison. So it's not as easy as he gets out in 151 months and then it's over. No, he's got another 20 years after that. And they say that he filed a timely notice of an appeal. And then on the appeal, they remind the court that he argued that the court violated his constitutional rights to present a complete defense by precluding him from calling and, if necessary, impeaching critical witnesses at trial. He also argued that this court erred by denying his motion to suppress statements after a federal agent physically stopped him from contacting his attorney and subsequently interrogated him outside of the presence of his counsel, and that this court erred by permitting the government expert to offer testimony on EXIF metadata and prohibiting his expert from testifying to the unreliability of the methodology used by the government's expert. The Eighth Circuit found that the court had unquestionably constitutional discretion to exclude the conviction under Federal Rule of Evidence 403, and as a result, the application of this well-established rule could not have violated his Fifth or Sixth Amendment rights, and that's to a complete defense. And his second argument, they found that the admission of his incriminating statements did not violate his Miranda. And as to Duggar's third argument, the Eighth Circuit determined that this court did not abuse its discretion in admitting expert testimony by the government's forensic analyst by metadata from Duggar's cell phone. And this court did not abuse its discretion by limiting testimony of Duggar's expert. So what Josh is now trying to do is he tried to get it so that James Futrell, the forensic expert for the federal court, he was allowed to testify about how they knew that this was him and how they were properly able to track everything so that they knew that it was Josh that had uploaded information, uploaded that he was the one that was viewing it, that it could be nobody else, right? And that now Josh's new argument is basically that James perjured himself and lied under oath. So when he couldn't get them to not allow him to testify and they wanted him to be thrown out, now they're saying, well, he just perjured himself. And so when it comes to the constitutional right with Randall Berry and with Caleb Williams, which are part of his motion to vacate, they said that the circuit court already ruled on this and they found that nothing had been violated. And then when it comes to the statements that he made, so Mr. Duggar is in his motion to vacate claiming that the HSI agent perjured himself and called statements that Josh Duggar had made, where he asked if anyone on the lot had been viewing CSAM or downloading CSAM. That wasn't recorded. And he's fixating on that because he's saying, well, it wasn't recorded, so it's just hearsay. But 2 agents heard him say it. So 2 witnesses heard him say that, right? And in the 30-minute Miranda interview where he waived his right to an attorney and he answered questions outside of his counsel, he asked a lot of questions and he made statements like, I'm not going to say I'm not guilty, or I'm not going to deny my guilt or deny guilt. I just don't know what to say. He asked about uploading or downloading numerous times, trying to get and figure out what his charges were. It was clear he knew why they were there. And that interview, the jury listened to while they were deliberating. And they didn't really care so much about his question that wasn't recorded. There was enough on that Miranda interview with when they met with him about the search warrant, there was enough on that interview that incriminated Josh. And it says, after the Eighth Circuit affirmed the judgment of the court, he petitioned for a writ of relief from the Supreme Court, which was denied. And that was denied on June 24th of 2024. And then on May 27th, he filed a pro se motion requesting appointment of counsel. The court denied the motion. And then on July 29th, the clerk of the court filed document 179, which was styled as motion to vacate under 28 USC 2255. The last page of document 179 is per standard practice, a scanned copy of the envelope from which the document was received by the clerk's office. The envelope is clearly addressed to the United States Attorney's Office and stamped received WDAR July 29th, U.S. Clerk's Office. Based on this filing, the court ordered the United States to respond to Duggar's motion by September 4th. And then on August 22nd, a document styled as a duplicate motion to vacate under 28, same thing, was filed on record. The last page of this is likewise a scanned copy of the envelope in which the document was received by the clerk's office. This envelope is postmarked by the U.S. Postal Service August 8th and was mailed from Dallas, Texas. This envelope is also labeled with a U.S. mail tracking code. As noticed by the clerk in the styling of the docket entry, the contents of the document 182 are exactly the same as 179, but for the intended recipient listed on the outer envelope. So he sent the first envelope to the attorney's office and the second one to the clerk of the court. As noted above, the document, the original, was filed by the clerk of the court on the 29th of July. However, what went unnoticed until recently highlighted by the filing of document 182 is that document 179 was not addressed nor directed to the court clerk of the court. Instead, the envelope was addressed to the U.S. Attorney's Office at 35 East Mountain Street in Fayetteville. And such document 179 was in fact legal mail addressed to the U.S. Attorney's Office and mistakenly opened and filed of record by the clerk's office. Legally, the fact that document 179 was mistakenly opened and filed is significant because it places a time limit on the filing of the 2255 motions. The limitation period runs from the date when the judgment of conviction became final. A judgment deemed final is on June 24th. So his time for relief would have ran out from June 24th, 24 to June 24th, 25. And the document 179, the mistakenly opened and filed version, was docketed on July 29th, over a month late, and as a result, his motion was not filed under subs timely. And then a legal aside, it says the envelope aside bears no proof that it was sent through the U.S. postal system. There is no postmark, and the stamps themselves are not canceled out. A clearer version obtained from the clerk's office is attached hereto as Exhibit B. This is a stark contrast to the envelope in document 182, which contains a postmark tracking and canceled stamps. And they have a copy of these that they attached. And it is weird how this got into their system and how it got mailed without it going through the postal service. So somehow a envelope ended up at the attorney's office, but it was late and it arrived without going through the U.S. Postal Service. Who wants to bet he made Anna drop it off or something? To avoid the legal default, Duggar included in the documents filed as both document 179 and 182 a signed certificate of service indicating that on June 24th, he placed a true and correct copy of the foregoing motion to vacate and set aside, correct to the prison legal system. And that as long as there's a rule that as long as you get it into the mailbox by the day it's due, it's deemed timely filed if it's deposited in the prison mail system prior to the expiration of the filing deadline. In this case, what has been filed as document 179 was not addressed to the court clerk, but in fact, legal mail directed to the United States Attorney's Office. In contrast, the motion currently filed as duplicate, which was received nearly 2 months after his cutoff for filing the 2055 motion, was properly addressed to the clerk of court and properly filed of record. Consequently, the clerk of the court mistakenly opened and filed as a document 179 legal mail addressed from Duggar to the United States Attorney's Office, and it should therefore be stricken from the record, and document 182 is correctly mailed to the clerk and filed on record of August 18th and should be deemed the operative original filing in this matter. To be clear, does intend to respond to the substance of all the allegations raised by him in his 2255 motion. However, the contemplated correction of the record is necessary to properly respond regarding his compliance or non-compliance with the legal restrictions and or the prison mailbox rule. To be clear, the United States is not casting blame on the U.S. clerk for the filing of docket 179. All available evidence supports that document 179. All available evidence supports that document 179 was in fact hand delivered by a third party, meaning an individual, not the U.S. Postal Service or a common carrier. And therefore, the fact is it was addressed to the USAO went innocently unnoticed. The United States intends to fully address this argument in its substantive response to the filing. So someone connected to Josh hand delivered this to the office. It didn't go through the Postal Service. And so they're saying that he did that to circumvent that he had sent it late. It should be struck from the record as it was legal mail mistakenly opened and filed. Consequently, the record should be corrected and reflect 182 should be deemed the proper motion. I noticed that this filing was actually signed by Clay Folks. He's David Clay Folks, but he goes by Clay. He's the actual U.S. attorney in the Western District of Arkansas. He was the one that gave the public statement after Josh's conviction. And I noticed he was part of this. And this is spicy, and I want to explain why. They have attached as exhibits the mailing addresses. So the two envelopes, the 179 and the 182. In this filing, they're claiming that they have evidence to show that somebody tried to bypass the prison mail system because he missed the deadline. So somehow someone got this envelope, right? And then they hand delivered it to the attorney's office. And then somehow the attorney's office, when it was hand delivered to it, ends up getting filed by the clerk of the court, even though it wasn't addressed to the clerk of the court, which could imply that there was something happening here, or I don't know. They're saying the clerk is not at fault, though, which implies that Duggar is. They also labeled the envelopes as evidence. So they have it government's evidence A, B, and C. That's even spicier. You can file attachments without it being evidence, but evidence can suggest possible criminal exposure for him. And how this is being framed by them is that based on the fact that the 182 document was post stamped from the mail system on August 8th, Duggar actually mailed it from the prison system on August 8th. Someone hand delivered it on the 29th of July. The stamps were on the envelope to make it appear like it was mailed, but it was never mailed, meaning it was hand delivered. Okay. There's no proof, there's no postmark, nothing. So it never came through the mail. They're saying that he signed this document under the penalty of perjury, that he put these documents in the mail system on the 24th of June. But that would be impossible because if he put the mail on the 24th of June, the post date would say it went out that day or the next day, right? So either the 24th or the 25th, but it didn't. It didn't actually leave the prison in Dallas until the 8th of August. So they're implying that he fabricated the certificate of service, lied under the penalty of perjury, and could be misleading the court because he missed his deadline and he wants to get this still on the docket, right? He missed the deadline. So he fabricated a statement saying that he did this all on the 24th. They're saying he lied. They're implying he's lying under the penalty of perjury. He really mailed it on the 8th of August, and then he had someone hand deliver it to the office. And somehow that means that he doesn't get the exception for the the mailbox exception, where as long as it is postmarked on the date of the filing, which would be the 24th, and it's given to the prison mail on that date. This is serious. Okay, so they need to first off, they need to handle the procedural issue. So the judge ordered that in their response, they can address all of these issues and they can present their evidence to the court about what they believe. And they're going to argue it was untimely. But they're also, I think, going to try to argue that he did all of these things to misrepresent to the court and lie because he missed his deadline, which is actually a fraud perpetuated on the court and possible perjury because he made a false statement under the penalty of perjury and making false statements to the court. It can be handled both civilly by tossing this out. So the likelihood is if they have evidence that he fabricated all of this, his whole motion is going to get thrown out. This attorney's office is hands down amazing at dotting all their I's and crossing all their T's. And it sounds like they are building a case against Duggar. And they're gonna ask the court to throw it out because it's untimely. And then I think they might be building a case for criminal charges, possible criminal charges of perjury, false declarations, because he certified that he mailed it via prison legal mail, which he didn't. Perjury, if they can prove that he intended to mislead the court, which they're highly suggesting, and fraud on the court, which means that he misrepresented the filing date to appear compliant, and it can be considered fraudulent conduct when it misleads the court. The U.S. attorneys told the court that they are going to argue that his motion to vacate is time barred because they're claiming that this document that was posted from hand delivered didn't go through the prison mail system. But the fact that they went through this long process and they have it all labeled as exhibits, and they noted that Duggar, they're implying that he did this to bypass the fact that he had missed his deadline. So say he might have had it ready and then he just forgot or something came up. I don't know. But they're essentially implying he's trying to manipulate the court and defraud them through having this one hand delivered and then this other one mailed. They have stated that he has a pattern of manipulative and deceptive behavior. And because he is such a good liar and he will lie about just about anything, and he's unwilling to take responsibility for anything that he does, they deemed him a dangerous offender. And they told the court at sentencing they were seeking 20 years plus, I think, 30 years of supervised release. They said that his likelihood of like reoffending is extremely high, but then anything else, like other charges, because he's such a liar, he can't tell the truth about anything. And we know that at the same time that all of this was going on, he violated the rules in prison and he had more time tacked on to his case, to his sentence. If they were to charge him, he's already listed as a dangerous offender. He's in there for a serious federal offense, one of the most egregious you can commit. If they were to sentence him, they could get another couple years tacked onto his sentence if they were to criminally charge him. But it would also help them show a pattern of behavior to the court and to the system that his criminal conduct and his criminal mind has not changed. We'll have to see if that's what their plans are. I could see it going either way. I could see it just being procedural. They don't want him out. They don't want it vacated. But I could also see them going criminal just for the sole purpose of getting additional charges on his record, because all additional charges and all deceptions that they can mark as proven criminal crimes against the federal government just further strengthens their case that they gave to the court 4 years ago that he can't be reformed. Like, they didn't want him out. They are petrified of Duggar getting out. They said children are not safe around him. So I could see them charging him. We'll see though. So Josh might face criminal exposure, but most likely on top of that, we'll have this entire thing thrown out. But are you shocked to hear about his deception on the court? I didn't expect this at all. And these prosecutors are phenomenal for catching this. Make sure to let me know what your thoughts are in the comments below. Please make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.